Welcome, my name is Paolo Annino and I'm talking about special education today. We're doing a 6-part series on special education and this is the 6th part of the series and we're talking about appeals. We're going to talk about the appeals from an individual education plan and appeals from a manifestation team meeting. So we're going to be talking about appeals today, and also we're going to be talking about is alternative special education laws in addition to IDEA, the Individual Disability Education Act, which we're really relying on primarily in this talk, but throughout the country. Okay, so you go to an individual education plan meeting, you sign the individual education plan saying that you disagree it provides a free and appropriate public education. You go back to your office, you talk to your colleagues, and you decide to file an administrative action. The hearing is before DOA, Department of Administrative Hearings, and it's a full-blown administrative hearing where you have the right to direct examination, cross-examination, opening statement, and you do proposed orders. So you file your notice with the school district and with the Department of Education. How long do you have to file your notice of appealing? You have 2 years. You have 2 years to file your notice. I don't recommend that. I recommend that this is something that has to be done quickly. I think it's important for a child to get a free and appropriate public education as soon as possible. So you file your notice of appeal to the school district and to the Florida Department of Education. They have 15 days to forward it to the Department of Administrative Hearings. And again, as I said, you get a full-blown administrative hearing. What's the issue? The issue is whether or not the child's receiving a free and appropriate public education. But in 2004, the Federal Act was amended to insert a new process, and that process is called the resolution meeting. Resolution meeting. So what happens is within 15 days of filing your petition, again, within 15 days of filing your petition, the school district has to schedule a resolution meeting. Now, what is a resolution meeting? Well, in many ways, it's a sophisticated, more substantive individual education plan meeting. It is a meeting where everyone now, because you filed your appeal, takes whatever you're asking very seriously. And it's set up like a IEP meeting. If you have an attorney present, then they're allowed to have an attorney present, the school board. If you do not have an attorney, then the school district cannot have an attorney at the resolution meeting. I do recommend that you do have an attorney at the resolution meeting because I think at this point, since you've already reached an impasse at the individual education plan, I think it's better if lawyers can try to put their hands around the problem and come up with a solution. So I do recommend having an attorney at the resolution meeting. And how does it work? It works exactly like an IEP meeting. You go around the room and you explain, and the school responds to why you believe you're being denied a free and appropriate public education. And again, is it because of the goals? Is it because of the program or placement? Is it because of the related service? Is it because of the least restrictive environment? Right? So there could be a number of different reasons. Or is it because of discipline? So that is the process. So the process is you file an appeal, you get a resolution meeting. Now, there's also, in educational law, mediation. You can request, after an IEP meeting, you can request, even before you file, this is interesting, even before you file a petition, an appeal that is, to the Department of Administrative Hearings, you can request mediation. So mediation can be requested at any time. After the resolution meeting, you can also request mediation. Again, our experience here at the center, and from my experience with talking to folks around the country, many conflicts with the school district get resolved at the resolution meeting. Because at that meeting, people take it very serious. They realize they're going to be going to court, to an administrative hearing soon. They don't want to spend the money. They don't want to invest the time. They want to resolve the problem. So you have folks starting to focus really on what's a free and appropriate public education. So again, my belief is that at the IEP stage, you do not need to be an attorney, but I do believe that when it comes to the resolution meeting and when it comes to the full-blown Department of Administrative hearing, you should be an attorney to advocate in this context. How do you win at a Department of Administrative hearing? Well, the primary way of winning, is having a good expert. You have to have a good expert to win, because that expert is going to have to prove and justify and explain why the child is not receiving a free and appropriate public education. By what? By evaluations, as we talked about in part 2. And it shows how important evaluations are. Now, from a point of view of attorneys, there was a United States Supreme Court case not too long ago, a few years ago, where the court really was clear: you don't have a right to expert witness costs. So costs for expert witness, you do not, even if you prevail at the Department of Administrative hearing, you do not have a right for your expert witness costs. You do have a right, though, to, if you prevail, to your attorney's fees, but not to expert witness costs. Another type of an appeal isn't from an IEP, but it's from a manifestation team meeting. That is where a child is being expelled. You can appeal that expulsion of a child with a disability, again, to Department of Administrative hearings. The hearing has to be within 20 days. And the only issue at that appeal to the Department of Administrative hearing, the only issue is going to be, there's two. Those issues are: is it a manifestation of the child's disability, yes or no? Was the child's behavior issue a direct result of the failure of the school district to implement the child's IEP? And the administrative law judge will be resolving these issues, just like the issue of the IEP, de novo. So these are de novo reviews by the Department of Administrative Hearings. If you lose either at the Department of Administrative Hearings, both on an IEP issue or on a manifestation team meeting issue, expulsion issue, you have the right to either go into state circuit court, or you have the right to go into federal district court. Again, you could go into state circuit court or federal district court. Now I want to turn to another federal law that protects children with disabilities. We just finished talking about the Individuals with Disability Education Act, but there's another major act that applies to many children with disabilities. Earlier on in this discussion, we talked about eligibility for IDEA. And what I said during that discussion, that to be eligible for IDEA was a two-pronged test. One was you have to fit into the category, and there's 10 categories, and two, your disability has to have adverse effect on your education. Adverse effect. And I gave the example earlier of a kid in a wheelchair child who is receiving all A's. Well, mobility impairment is a category under IDEA, but because the child's receiving all A's underneath my hypothetical, that child then would not be having an adverse effect on his education. So the child would not be qualified under IDEA. That doesn't mean that this child doesn't have protections. This child does have protections. There's an older law. There's an older law that applies, and that's called the Rehabilitation Act of 1973. I'll give you the exact site. Section 504. On the Rehabilitation Act of 1973. The exact site is 29 USC 705 20B and 29 USC 794. Okay. So what does this federal act, how does this apply to children with disabilities? First thing, Section 504 of the Rehabilitation Act of 1973 applies to more than just education. It applies to any entity that receives federal funding. So any entity that receives federal funding is prohibited from discriminating against people and children specifically with disabilities. So 504 prohibits discrimination based on disabilities. So the child with disability, with the wheelchair, would be a Section 504 child, because the child does not fit under IDEA, because the disability is not having an adverse effect on his or her education. Under Section 504, you just have to have a disability that meets the statutory requirement. Now, what is that statutory requirement? Well, it's a two-pronged test. It has to, your impairment, whatever impairment we're talking about, a mobility impairment, a mental health impairment, your impairment must substantially limit a life function. So your impairment must substantially limit a life function. So you can have a variety of impairments and life functions as walking, talking, socializing, learning. So it's an impairment that substantially limits a life function. And again, the case of the wheelchair would be an example of that. And the life function there is mobility, walking. That's what it limits. So how do you go about getting a 504? And we're going to talk about, it's a 504 plan, just like an IEP plan. This is called a 504 plan. Again, 504 IDEA applies to preschool, elementary school, middle school, high school. 504, it doesn't, so IDEA does not apply to colleges, right? Or graduate schools. 504 applies to everything, as long as you receive federal funding. And all public schools in this country receive federal funding. So IDEA applies. Sorry, excuse me. 504 applies. So 504 applies to all schools who receive federal funding. So how do you get a 504 plan? Let me just say, in some school districts, instead of using the phrase 504 plan, they call it an accommodation plan. So some places call it an accommodation plan. Other places kind of use, based on the name of the statute of the act, they call it a 504 plan. So how do you go about getting a 504 plan? Well, it's very informal in many ways, much more informal than an IEP or IDEA. What you simply do is you make a request to the principal or the special education coordinator or the district special education director, asking for a 504 plan. And what does a 504 plan have? When we talked about IDEA, we talked about the 5 major components of IDEA. We talked about goals, we talked about present level performance, we talked about related services, least restrictive environment. we talk about the different components. When we talk about a 504 plan, we're really only talking about one thing, or one category, and that category is called accommodations. So really, a 504 plan is much, much, much shorter than an IEP document. Usually it's only 1 or 2 pages, and what it is, it's a list. It's a list of different accommodations you're going to provide, you meaning the school district, is going to provide to that child. Again, example is a child with a wheelchair, and again, this is one that my center worked on. In that, the child wanted to take an advanced math class at his local high school. The child used a wheelchair. The advanced math class was being held on the 2nd floor of the high school, and there was no elevator. So we requested to have a 504 meeting to create a 504 plan. And in that meeting, remember, again, this is like tunnel vision here. At that meeting, we're focusing on what? Accommodations. We're saying that this child is being discriminated against because of the school's failure to provide him accommodations. So we argued that the child needs to have accommodations so he can take this advanced math class. The way it was resolved in that case was we were able to resolve it by having the school agreeing to transfer the room from the 2nd floor to the 1st floor. Another case is, and this is, again, this happens, the child needing ramps. So the school has a variety of classes, and there's different levels, and there's no ramps. Again, that's a perfect accommodation for a 504 plan. What the 504 plan would say is the child will have a ramp in each one of his classes. So for whatever accommodation. Another example would be a child with diabetes. And that example would be the child with diabetes has to take her medication at a variety of times. And the accommodation would be is that she can take her medications at any time she wishes in the classroom. So you can negotiate during the 504 plan meeting what specific accommodations you believe the child needs in order not to be discriminated against. Let me just give one more example on 504. This was a child who was called Lyme disease. This child was not thriving because of his Lyme disease. He was really just totally emaciated, this little boy. And he did not have the strength to carry home his books from school. So, but again, the child was doing very well in school. So the child was not an IDEA child, but because the child, remember IDEA, you have to be both the category and adverse effect. Whereas Section 504, you only need a disability that meets the requirement, again, an impairment that substantially limits a life function. So in this child's case, the child with the Lyme disease, we had a 504 meeting with the school to create the plan, and we asked for an accommodation, because that's what you list. You list the accommodation. We asked for a second set of books be kept at the child's home, so he would not have to carry the books at home because he wasn't strong enough. The school district disagreed. They said, no, the accommodation we're going to offer him is that his brother carry his books. But the problem was his brother had extracurricular activities, and there was a lot of difficulties with that. So again, we ended up going to a hearing on whether or not that accommodation that we asked for was a reasonable accommodation that would prevent the child from being discriminated against based on his disability. So 504 is very important for those children where you cannot find an adverse effect on the child's education based on disability. Many times, though, people tell me, oh, this child is both a 504 child and an IDEA child. Well, you know, if you're an IDEA child, that means you're having an adverse effect, and all the services you need, and accommodations can be provided under IDEA. You don't need to have both. There's nothing that prohibits having both, but it doesn't make any logical sense why you need to have both documents. Okay, so a 504 plan then is. Let me talk about the 504 plan. So you go to a 504 plan meeting. You should have a 504 plan memo, right? Just like an IEP memo, just like a manifestation team memo. And in the memo, you need to list what accommodations you are requesting, you're asked. Again, just like we talked in part 2, you need evaluations to justify that this accommodation is the appropriate accommodation to deal with the child's disability. Okay. So again, you need to justify whatever you're requesting. Now, you go to the 504 meeting with the school and you reach an impasse. You cannot agree on the accommodation. Do you have a right to appeal? The answer is yes, but it is not as simple in many ways as with the Individuals with Disability Education Act. With the IDEA, you appeal it to the Department of Administrative Hearings, and you have a formal, full-blown administrative hearing. Whereas if you're appealing a denial of a 504 plan, the appeal goes to the school district. So you appeal it to the school district itself. And then the school district decides if they're going to keep it in-house and do the hearing themselves, or if they're going to contract with the Department of Administrative Hearings. As you can imagine, if the school district is doing the hearing themselves, then there's always a question of impartiality, right? There's always a question of impartiality. So you really don't want the school district to be the hearing officer at a 504 appeal. You really want the school district to refer the 504 appeal to DOA, just like they do under IDEA. But they're not required to. So that's the main point I want to get across. It's up to the school district, and whether or not under a 504, they'll do the hearing in-house, or whether or not they go in contract to the Department of Administrative Hearings. Okay, well, next then, next I want to turn to then is McKay Scholarships. And now this is totally different. We're moving away from IDEA, we're moving away from Section 504. Those were federal laws. McKay and let me give you the Florida statute number. McKay, 1002.39, is a Florida thing. It's a total creature of the Florida legislature. And the McKay is what I call part of the alternative schooling that's been going on in the last 20 years in the United States, moving away from the public schools to charter schools, to private schools, to homeschooling. What McKay's scholarship, McKay statute does is, if a child, now this is a qualification, if a child either has a 504 plan or an IEP. So the child either has to have either a 504 plan or an IEP for McKay to apply. If they do have either one of those documents, and if they were in school, a public school for the last year, so they have to have an IEP and a 504 plan, and they have to be in the public school for the last year, then they can do the McKay route and opt out of the public school. Not give any reason, by the way. They're not required to say, oh, I'm opting out because the public school denies me a free and appropriate public education. No reason really required why they're dissatisfied with the public school. But they're allowed to opt out of the public school and go into a private school or to another school district. So the option is, if they meet the qualifications, which are pretty straightforward qualifications. And by the way, Department of Education, Florida Department of Education, has a great website that spells out the details of the McKay Scholarship. But it's also in Florida Statutes 1002.39. But again, you just need a 504 plan or IEP. You have to be in school for the previous year. They just made an exception for the children of our armed services. So if the child is a child of someone from the military, there is some exceptions that you don't have to be a year prior into the public school system for those children. So what occurs is they look at your IEP document, the school looks at the IEP document, and on the top of your IEP document, usually it's right here on the top right-hand corner, there's something called a matrix number. A matrix number. It has nothing to do with the movie Matrix, by the way. Anyway, it's a matrix number. And based on that number, it determines how much funding the child has for private schools. So based on the matrix number, it determines how much money the child is going to receive for private schools. And so it's very important that if a parent is planning to use McKay Scholarship, that they know what their matrix number is, and it's at the IEP meeting or at the Section 504 meeting when that matrix number is adopted. So the law is clear on this, that those are the vehicles to adopt your matrix number. So if a parent doesn't agree with that number, that is where they need to argue it. Okay. So, but once you have your matrix number, that translates into a specific sum of money. And then with that sum of money, you can go to a private school. And if that private school accepts that amount of money, you can go to a private school for your educational services. Are there some advantages of the private school? Well, some parents think because of in Florida right now, and like many other states, but we took the lead in testing, well, the private schools are not required to do the FCAT. And so that's sometimes an important factor for some parents. So McKay Scholarship is for those parents and advocates who really think they can't receive a free and appropriate public education at the public school. But for whatever reason, there's no reason required. They opt out as long as they have a 504 and IEP plan, and they go into a private school for their schooling. So let me just kind of summarize where we are. Children in the foster care system, more than any other population, have stressors, they have a lot of frustrations, and they're behind in school. And we know that if we're going to really stop poverty, we're going to stop the cycle of children that becoming adults and entering the foster care system, we know that the only way of doing that is through education. And that's why it is so important. I want to again thank Alan Abramowitz and Thomasina Moore for making this an important issue, that advocates know how to help children in the special education system so they stay in school not drop out, and they go to grade level and not get frustrated, and so the children can actually flourish. If you have any questions, if you're with the Guardian Ad Litem program and you have any questions about special education, you can feel free to email me at pianino@law.fsu.edu. So pianino@law.fsu.edu. With any of your questions, I have a lot of emails, so it takes me a while to get back with you, but I will get back with you eventually. So thank you, and I appreciate all the work all you folks are doing out there trying to help our foster care children. Next we're going to go to is in cyberspace. We received several questions, so now I'm going to try to address several of these questions.